Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise, Howell, Emory, Roane, and Mike Keyes. Episode 371, recorded December 2016. Best of 2016. This episode of This Week in Law is brought to you by Blue Apron. Blue Apron will send you fresh, high-quality ingredients to cook delicious meals with simple step-by-step instructions right to your door. See what's on the menu this week and get your first 3 meals free with free shipping by going to blueapron.com/twit. Hi, folks. Denise Howell here, and you're about to enjoy our Best of 2016 episode of This Week in Law. We have done lots of fun things on the show in 2016. We started out the year talking about warrant canaries. At some point, a seagull selfie came along, and in fact, we instituted our animal selfie of the week in 2016. We've talked a lot about drones, both delivery drones, hobby drones, commercial drones of all kinds. We've had guitar-playing musicologists, encryption-loving technologists, and much, much more throughout the year. We hope you'll enjoy this best of. So obviously, lots of words can be trademarks. Trademarks are used in a certain area of commerce by certain companies that register them. And if you're in a different area of commerce, you may well be able to register a trademark that has already been registered by somebody else. It just, you're trying not to confuse the public and consumers. So when you throw hashtags into the mix, things get interesting. Can you tell us a bit about this, Reg?
So the hashtag, the Twitter, pound symbol, everybody uses it. Everybody who tweets uses it. Everybody who Instagrams uses it like, whoa. Tumblr also has it. And recently, people have been applying for trademarks in it, which is just totally bizarre to me because hashtags are sort of by nature ephemeral, right? I used a hashtag yesterday, KSK, that was really only relevant yesterday. And today, maybe somebody else will use it for something different. And the nature of hashtags being so ephemeral, the fact that people even want to trademark this is just absolutely baffling to me. And I put it right up there with Taylor Swift trying to trademark This Sick Beat. I don't even know what people are thinking.
All right. So can you give us some concrete examples of things that are not yet a trademark, but have been given life in the hashtag arena and someone has trotted down to the USPTO?
I think this was the blurred lines case that you're talking about. I'm looking at the BuzzFeed article, and blurred lines is 2 words in trademark, as far as I know, and they combined it and threw a hashtag on it and have applied for it. I don't believe, though, that it has been granted yet. Am I wrong in that?
I'm not following it, so I'm not sure.
This is, I'm just looking at it from, right, exactly. I don't believe that it's been granted yet. It's difficult to convince the Patent and Trademark Office to grant a patent for even domain names. Certainly, you're not allowed to patent a top-level domain. So I don't think any of these are going to pass muster. And with the length of time that's required to get a trademark on it in the first place, I don't think it's going to be successful for anyone at all.
All right. Emory, any thoughts?
I don't have great expertise in trademarks, so I'm going to avoid saying anything and putting my foot in my mouth. But it just seemed, from my cursory understanding of trademark, that this would be the kind of thing that businesses would jump at. Informing consumer expectations. I would think that McDonald's would be all about trademarking hashtag I'm loving it or something like that. But I think that overzealously trademarking things is never a good idea.
Right. And I'd also say, I'm loving it is also just a phrase that people might use. And you might say it in a tweet ironically and say, I'm having breakfast at my mom's, hashtag I'm loving it. And I don't think anyone thinks that that's an endorsement of McDonald's or even an incorrect use of the trademark if it were a trademark.
Yeah, it seems to me like there actually needs to be some clarification from the USPTO as to when it's going to be okay or if it's going to be okay to trademark a hashtag, because trademarks traditionally have been used to identify a business, and by definition, a hashtag is used to further a conversation in whatever forum that it's being used in, Reg. As you mentioned, all of the various ones where you're likely to see.
Well, I think hashtags are used to signal something. They're used to signal expectation, signal, cue in a reader that there is a larger dialogue going on related to, whatever they're hashtagging. So I don't know.
Right. They can't use
what I'm curious is why would they trademark something? What would be the regressive
to suggest that there might be a conversation around something that actually there is not one around, but is just funny to throw into your post.
Well, right. And sometimes I will throw in a really long and obnoxious hashtag as a joke, right? So hashtag I'm having breakfast at my mom's. Because Instagram and Tumblr actually support hashtags with spaces in them. So you can have a hashtag on Instagram and Tumblr. Actually, maybe it's only Tumblr that supports it. But you can have a tag. Back when we blogged, right? These were just called tags to categorize your post. And it can be multiple words. It can have a space in it. So Tumblr and Instagram are notorious for having these really long hashtags. Twitter, you don't get them as long because you are limited to 140 characters in total. So when you see a really long hashtag in Twitter, it's more of it's for comedic effect. But I don't really think that these are trademarkable as for the points that you brought up, Denise, because it's not really distinguishing a business. If anything, it's distinguishing a particular advertising, a marketing plan of the business, right? It's not hashtag McDonald's, it's hashtag I'm loving it. Those are two different things.
Right. Tiffany, anything for us on this?
Sure. I think that first we should recognize the genius of Alexandra J. Roberts' BuzzFeed article. I love seeing complicated legal issues written about primarily using GIFs. I think that's fantastic. I mean, it's a very new concept, right? This trademarks of hashtags. So I think this is a very novel way to introduce the topic to an audience that probably doesn't want to read a law review article. By the way, though, I am attending the Works in Progress IP conference at the University of Washington next week. And the one works in progress that I'm most excited to hear about is actually the law review article Alexandra J. Roberts is writing on this topic. So I'm sure that this is going to actually be a concrete legal analysis. But for now, the BuzzFeed version is also good. It's interesting. Honestly, I don't know if it's going to be an issue that we look to in maybe 5 years. I think we're already seeing that younger people, the kids and teens these days, aren't really using hashtags as much as they used to. So if they are the future of the internet, then the future of the internet might not need trademarks for hashtags.
It might not. Emory, were you serious before the show that you were not aware that BuzzFeed's format was pretty much headlines and GIFs?
I mean, I knew the reputation, but I didn't think that literally the format of their article is headline GIF, headline GIF, headline GIF, byline. That's it. That's literally the entire thing. And I've got to say, Tiffany, you have cast it in a much better light than I initially had when I saw the article. But I can get behind what you're saying. We do need, if this is how you educate lay people about, complex legal issues, I guess this works.
Yep. I can get behind it, I think. I can also get behind it as Drake's next song. Instead of Hotline Bling, Headline GIF. Why not?
There we go.
Yeah.
Yes.
I guess one question I had about this to hopefully to our other guests that are more knowledgeable about trademarks than I am, but when we get down to it, I don't really understand why you would want to trademark a hashtag. I guess what would be the redress ability if you the situation would be that someone would trademark Deflategate, and then whoever owns that trademark could then send takedowns to people that use that hashtag? What?
Right, that's the other part of this that is absolutely baffling to me. If McDonald's trademarks hashtag I'm loving it, and I don't know why I'm fixated on that one, that means that I cannot tweet it. So I cannot go to McDonald's and say...
Undermines the whole purpose of the hashtag.
Right, I am enjoying my Big Mac. Hashtag I'm loving it. That would be an infringement because I am not authorized to use the trademark. If I am authorized to use the trademark, then it's not a trademark. So this whole thing is just, I feel like some lawyers got their hands on something and decided to run with it and just don't understand the technology, honestly, because it's ephemeral. It's supposed to signify a conversation, and it's supposed to encourage additional conversation about that thing. And if you trademark it, it's no longer ephemeral, and it shuts down the conversation because you limit who can speak about it, who can use the word.
Yeah, that was my question. Awesome.
Tiffany, what were you saying?
Sure. I think what's key here is that companies probably won't shut down all mentions of their trademarks, right? Even if they can trademark a hashtag, they will only use that, that trademark power to shut down uses of their trademarks that they don't want. So, for example, if you tweet something with "I'm loving it" next to a picture of McDonald's hamburger, I'm sure they won't try to shut that down. If you tweet that next to, say, a picture of something negative about McDonald's, then they can actually shut it down. So I don't think this is going to be curtailing speech really, except for the type of speech that companies don't want. So there will still be use of the hashtags, but this will just be a way for them to manage, how to manage their brands online, which really is the core of trademark law, really, the ability to manage the intellectual property that you own.
So correct me on trademark law then, because my understanding is that if I don't police the mark, I lose the mark, right? So if somebody out there is using my company's trademark and I am not authorizing it and I don't shut it down, then I lose the ability to authorize it to other people in the future. Is that not correct?
So what I would predict would happen would be that the companies would still, like you said, police the mark. They would look for infringing uses. They would shut down some uses, but I'm going to guess that they would allow some more innocuous uses on Twitter, on Facebook, things that they actually like. And this would still be considered them kind of keeping tabs on their own trademark, because they would still be shutting down probably a significant number of blogs, tweets, Facebook posts about their trademark.
Okay,
but Denise,
so as long
you know
as
more about this.
Well, I was just going to say that I think there's something to what Reg brings up, and that this is possibly a door that trademark owners do not want to open, because if they do decide to try and selectively police hashtag speech, they might find themselves losing a trademark in the bargain. If we had Marty Schwimmer on the show, who is our semi-regular trademark expert who comes on, he could tell us all about this. So maybe we'll bring him on soon and resurrect this topic. But I personally can't tell you how much policing is enough to be able to keep your mark. But I know that there's at least a danger that what Reg is saying could happen if you decide, that actually helps us, so we're going to let that one stay, or that one disparages our brand, so we're going to ask to take it down.
I think it also has to do with who's using it. If it's just the general public who are allowed to use it, I think that would go into the factors of whether or not the policing is taking place.
There's also the issue of in Maryland, and I know Maryland is pushing a bill right now, but California currently has one that prevents companies using sort of gag orders or gag clauses in their contracts that prevents people from going to Yelp and writing negative reviews about the business. So I would imagine that at some point there's a free speech issue here about using this hashtag to review bad business practices. Whether or not that would, if companies could use a trademark issue to take down bad reviews because it says hashtag I'm loving it. Ironically, we really got to move on from hashtag I'm loving it. But
right.
Yeah,
another one is
actually McDonald's.
Yeah, not at all. But one of the examples in the BuzzFeed piece is ask JPM, ask JP Morgan, from tweeted by someone who was highly dissatisfied with their services, and was making that clear by co-opting their own marketing hashtag. This is about, it's a BuzzFeed piece about aerial surveillance in the United States. Lindsay, let's start with you on this to tell us what exactly you learned from this piece.
Sure. So BuzzFeed did an analysis of flight patterns, and basically they found out that there are FBI and DHS aircrafts that are circulating particular areas. Sometimes they have cell phone devices on them that work like a cell phone tower where they can intercept your cell phone signal. There's concerns that Muslims might be being targeted by these aircrafts. So definitely some gray area with surveillance aircraft that we do not know are in the sky, but maybe collecting information about us, what you can see, as well as information through the airwaves and Wi-Fi waves.
Right. So we think about spy planes possibly being over other countries, not so much over ours, but increasingly you can see why they might be. How exactly did BuzzFeed get this information? Where did the data come from?
I'm not actually completely sure. I think that they got it from the FAA. I'm looking through it now.
There's a website called Flight Radar 24 that has publicly available flight information for all flights. So this is a really great example of awesome investigative journalism using open data. This is stuff that the EFF, that the ACLU North of Northern California, a couple other people have talked about before. The idea that the FBI is flying over American cities with stingrays on their planes to spoof cell towers, to do surveillance over neighborhoods. We've heard that, but this BuzzFeed article, which, by the way, I was only slightly disappointed there weren't more GIFs. But this BuzzFeed article,
it's very GIF heavy.
really went into the meat of it, and they did their research and expanded on the findings of the EFF. They found that the FBI has over 100 fixed-wing airplanes, more than a dozen helicopters that they're using, that just in the 4-month period that they were studying had more than 1,400 flights. And that's pretty bizarre. The idea that when you think of, everyone likes to think of the spying as like an NSA purview with, drones flying way above, the stratosphere and using super high quality cameras to spy on countries far away. But no, this is just a bunch of Cessnas flying very low to the ground with some good cameras. It's expensive, but not that expensive. And yeah, when we're looking about how these flights are going, we're seeing them circling over mosques, and we're seeing them circling over specific neighborhoods. This is information like when we're not to get put on my political hat or anything, but when we're hearing rhetoric in, the race to the White House 2016, and then we see that we already have the FBI totally okay with flying, surveillance circles around mosques in specific Muslim neighborhoods or Somali neighborhoods. It's pretty scary. This is a really great article. I highly recommend everyone check it out.
Yeah, it's fascinating, and actually the GIFs and graphics, unlike many BuzzFeed articles, are really, really informative.
Yeah,
as opposed to simply entertaining with cats. So it's quite eye-opening. I don't know that I'm necessarily not okay with it. As long as they're operating within the law and not, we're talking about. I suppose I was about to say we're talking about people out in public, but this would track you wherever you are. If you're in your home, it would track you there too. If they're using stingrays to get your cell phone to connect to them as though they were an actual cell tower. So I could see where there could be some Fourth Amendment concerns here. But putting on my idealism hat and thinking that there could be a way to do this and honor people's Fourth Amendment rights, I'm kind of excited to see that the government has this level of sophistication. I don't know that the first part of my premise actually can play out, though. Mike, what do you think of all this?
Yeah, I was very surprised to see this was so extensive and to look at some of these flight patterns, particularly after the San Bernardino attacks. I thought it was pretty fascinating to see. I'm with you, Denise, though. I'm not so certain that I'm frightened or think this is appalling. There's all sorts of government intrusions that I think have been happening for a number of years, some of which have made their way all the way up to the U.S. Supreme Court. So I'm not so certain that this is awful or frightening or terrible. But frankly, it was surprising to see how prevalent it was.
Mm-hmm. If I could chime in just quickly,
sure, of course.
I think that especially if you read this article, it's clear that, at least according to the FBI, that they're using these for causes that certainly seem justified. Sex trafficking, murders, drug trafficking, gang violence. My fear is that, it's not necessarily the use today, it's the use tomorrow. What we're seeing here is, the practice being normalized that we're okay with the FBI sending up planes, all day for 5 days a week, because apparently they don't work on weekends if you read the article.
It's the government after all.
But, the worry is I watched a great documentary on Nova a couple years ago about drones and their surveillance capabilities. And one of the things they talked about is the ability that once you have planes above a city flying regularly, you just do that as a regular practice with high quality cameras, then you can essentially time travel whenever anything goes wrong. So my worry about that, this is quite literally the eye in the sky, Big Brother fear, where eventually we just have these planes flying all the time, every day on our major cities. And if anything happens, or if any protest happens, or if, a journalist who says X, Y, and Z against whoever is behind the button that controls the FBI planes, sorry for shaking my screen there, I don't like the slippery slope argument, but here especially, I think that it's worth considering that, down the line, do we want the police or our government to be able to just press a button and pull up a complete, record of what's going on in the city and be able to zoom down to the individual and follow them through traffic and, know exactly who they connected to and map that network out? Personally, I think that's a little scary, but it's certainly technically sophisticated. And according to the article here, it has secured, hundreds of arrests. So it's a discussion worth having. I would personally just like to see more transparency about this. I hate that, we needed a BuzzFeed investigative article after multiple watchdog organizations have been saying this and getting no coverage for months before we know this for a fact, If we just had, what if we all had a debate or what if a public official proposed this even, and we could talk about it. But instead we just have eye in the sky.
Right.
It seems to me, Denise.
Go ahead, Mike.
In some respects, this aerial surveillance is maybe even a little less intrusive than some of the video cameras and other such things you see on street corners these days.
Mm-hmm.
There's you at least here in Washington, in various cities here, Seattle, Spokane, you've got all sorts of cameras and other things that are monitoring people's daily activities. So I'm not sure that aerial surveillance from a mile above is any worse than what's already going on right now.
Well, that's exactly what I was going to say, is that we can be, or suspects can be tracked pretty readily, even without planes in the sky, just based on the other cameras and surveillance that are out there and operating already. This just seems to be another piece of that puzzle. And
they're bricking the wall. No argument here, but
Yeah.
I think the biggest difference for me is that with a street camera, you can a lot of times see the street camera. So you don't necessarily have as large an expectation of privacy. Whereas with one of these planes, they do have mufflers on them where you can't hear them, where maybe you can't see them as much, or even if we are approaching drones, which it seems like this is going in that manner, you might not be able to see it at all. It might be really small. So I think that is a difference. And then also the transparency piece. For example, these planes were used in Ferguson, Missouri. We don't know why. If we looked at a street corner video, that's something that could potentially be available under the Freedom of Information Act. You can see that, you can know it's there, you can get it. Whereas with one of these planes, we don't know why the plane is there necessarily. We don't know what it's capturing. We don't know how to get it. So it's definitely less transparent.
Yeah, definitely. The headline on this from TechCrunch was Uber shared 14 million users' info with the government, transparency report says. What I think a fairer headline would have been giving Uber a kudos for issuing a transparency report, and along with Twitter and a number of other technology companies actually letting people know, Microsoft, various others, Google, of course, let people know what sort of requests they're getting from the government and how much information they've turned over. And so Uber is the latest to do this. 14 million users' information was disclosed to law enforcement and regulatory agencies, according to its report. Most of that consisted of ride information for more than 12 million users. So here's the government trying to get information on its investigations from how people are riding around in the world in their Uber cars. What do you think of this, Emory?
Oh, I thought it was a great read. Obviously, this information is going to be tracked. When we're talking about problem areas on applications, the example that is always brought up is that, if I open Uber on Tuesday and then don't close my phone until Friday, Uber's been open the whole time. And, ostensibly all that information is tracked. And well, yes, it is. And it's very valuable, obviously. I think that if you read the actual transparency report, it's pretty interesting. Going down the list, a full, almost 20% of the requests were from airports. So obviously, it's clear to see why the government would be very interested in tracking drivers and rides from airports. And with airports, 100% of those requests were fulfilled. They do actually go down and provide granular information about how many requests were fully complied with or partially complied with, or how many requests they were able to negotiate down. Transparency is great. I agree that, Uber probably needs to be given a little kudos for releasing transparency reports. Ideally, in a perfect world, transparency reports would just be required by either the organization requesting the information or the businesses whenever the requests are made. But yeah, this is a great step.
Right. Emory raises a great point that, of course, lots and lots of other businesses turn information over to the government all the time without telling you or anybody else about it.
Yeah, let's not this is not at all. Uber gave 14 million reports to, or 14 million customer information to the government, and Lyft did not. No, I mean.
Right. Transparency reports are good and help you understand exactly how your data that you're putting into these apps can be used. An interesting point, too, is that Uber now has a warrant canary. We talked about that several episodes ago when we had Declan McCullough on the show. A warrant canary is a statement somewhere. It's either in the report or elsewhere on the website saying that as of the day that was published, Uber has not received a national security letter or a FISA court order. The reason warrant canaries are important is when they disappear, then you can go ahead and assume that the company has received such a letter or FISA court order, which requires them to cooperate with the government without telling anybody about it. Mike, any thoughts on this?
Just seems like it's a tremendous amount of data that was shared with these various law enforcement agencies. I mean, 14 million different users, many of which in places I suspect people would logically associate with some of these requests, were a lot coming out of California and some of the other major metropolitan areas. So very interesting as to what's going on with all these requests and how exactly this information is being used. I can understand, Emory, as you were referencing, a lot of information related to Uber driver and rider activity at airports, but outside of that, it's interesting.
Yeah, we're seeing them in California, Chicago, and New York City in particular are the highest centers, according to the data that they provided here, with almost 6 million of the requests coming from California alone, and another 2.8 million requests from New York City alone. So a full 50% of the total requests are from, all of California and New York City. So interesting.
I found it interesting. Sorry. Go ahead. Tell us about the warrant canary.
I just wanted to chime in. I'm not sure if we covered it last week or the week before, but Reddit made waves because their warrant canary was conspicuously absent. From their 2015 transparency report. So as of a couple weeks ago, at least we know that the warrant canary system works, and that we can be confident that Reddit has received a letter.
Yeah.
So. Not to derail the conversation.
Yeah, no, not at all. The other thing I found really interesting about this, in sort of the similar way I found the usage stats on the Apple Watch and other wearables interesting, is just the penetration of Uber and how many people have made it routinely a part of their lives. I guess I'm less surprised about that than I am about the wearables. I mean, Uber just seems to be ubiquitous. Lindsay, are you on board with that? Do you see it everywhere?
Oh, yes, definitely. But I think it's also important to recognize that even though you see it, it's so common, especially if you live in a big city, like I live in Washington, D.C., it's still very easy to re-identify me in that data. So, for example, if I'm taking Uber every day or every other day or twice a week to or from work, it knows where I work. It knows probably where my apartment is. And just with those two pieces of information, you can very easily re-identify someone. And that's definitely of interest when you consider how unsecure your data is and how prone to hacking it is, especially when it gets into a lot of these different hands. So definitely something to watch out for there.
I think that's actually the crucial point that is frequently ignored. And like the elephant in the room is that like hacking, data security is really, really hard. And I don't think that anyone has shown themselves able to be worthy of being trustworthy holders of our data like this. It doesn't matter how big or small the organization is. Everyone is just as vulnerable to spear phishing because you're just as strong as your weakest link. And so, yeah, the fear is not necessarily like so frequently it's like, oh, I don't mind if this company or even if the government has this data. But we're not talking about that. It's when you have all these huge, valuable stores of information, they just have the biggest red target on it. And if it hasn't happened already, it's going to happen eventually where that information is going to get into someone's hands that you would not like it to. Most likely.
And certainly those hacks are so common. I mean, I had my information hacked, and the government hack, the large one that happened like 6 months ago, a year ago, where I had my fingerprints, my social security, all of that
biometrics.
Stuff.
You can't unlock your phone securely.
Had all of your health data and all of your Uber data in that hack. I mean, that would be crazy.
Yeah.
So what was the upshot of that, Lindsay? Do you feel like the government took adequate steps after that happened, and have you had unforeseen consequences?
I have not had my information, as far as I know, nothing has been done with my information. They sent out a letter letting people do credit monitoring, but I do think that once your information is out there, it could be years. You really have no idea what could happen with it. So,
yeah. All right.
I think that according to a conference I just went to, the government offers something like 3 years of, identity protection, identity theft protection. But then you're thinking, well, that's the whole reason why people are stealing biometric information. It's because you can't revoke it. And so you're going to see organizations that have these massive, when we're talking about data breaches in the millions, of course, they're not going to jump and use the data that they just grabbed last week. They're going to hold on to it and wait 5 years down the line, 10 years down the line. It's still going to be equally valuable. And that's the real fear, is that, we have not seen a lot of these data breaches come up on the black market yet, because in all likelihood, they're probably just sitting on them and they're still valuable. So super scary stuff out there.
Yeah, and Beatmaster in IRC is mentioning HTTPS, of course, haveibeenpwned.com, PWNED, as a resource to check out. Do you know anything about that, Emory?
I've heard it.
Run myself through it.
Yeah, I've heard it before. It came up. Security Now was talking about it a couple of years ago. It's a great resource. I haven't dug into, the organization behind it or how extensive their data breach database is. But yeah, essentially what it lets you do is you have a very simple platform where you can go in and enter in your email address, and it will tell you if your email address has come up on any of the massive data breaches that we have access to. So looks like my email address is still safe for the time being.
Right. I mean, probably your email address is the it's not something that I think a lot of people would be necessarily worried about, right? It's a pretty public thing. If your email address is out there, that doesn't necessarily mean it's been...
the accounts that are tied to your email address. So, for example, actually, I put in another email address, and I have been pwned in the Gawker breach and a couple of other breaches. So I'm not safe.
I see.
Sorry.
This is our first show from the brand new East Side studio. This is, look, there we are. Love it. We're looking very virtual there in the studio. But I was watching the move-in footage when that happened. I haven't seen any shows from the new studio yet. Our show we're recording now is my first view of the finished product, and it's looking great, Victor.
Yeah, what's funny is I'm actually zoomed in a little, so off to the right, Jerry's actually painting some of the wall, so...
I was going to say, listeners can't see this right now, but we are 3 screens on the in the new studio desk, and I think that we need some sort of either paper cutouts or some sort of animatronic bodies to go underneath the monitors to bring this to the next level. But maybe that's for the next studio, so I don't want to put too much on your plate right now.
We still have that iPad robot around here somewhere.
That's what we need. 3 of them. Thanks so much, everyone, for joining us for this Best of 2016 episode of This Week in Law. It's brought to you by Blue Apron. Blue Apron is the #1 fresh ingredient and recipe delivery service in the country. Their mission is to make incredible home cooking accessible to everyone while supporting a more sustainable food system, setting the highest standards for ingredients, and building a community of home chefs. Particularly during the holidays, you're going to love Blue Apron delivering seasonal recipes along with fresh, high-quality ingredients to make delicious home-cooked meals. Each meal comes with a step-by-step, easy-to-follow recipe card and pre-portioned ingredients that can be prepared in 40 minutes or less. You're going to save time and money. Shopping at the grocery store is 60% more expensive than Blue Apron. If you spend a lot eating out or at high-end grocery chains, you can now spend under $10 per person for healthy home-cooked meals. Customize your recipes every week based on your dietary preferences and choose a delivery option that fits your needs. There's no weekly commitment, so you only get deliveries when you want them. Blue Apron delivers to 99% of the continental United States now as well. Blue Apron sets the highest quality standards for their community of over 150 local farms, fisheries, and ranchers across the United States. Blue Apron not only supports a more sustainable food system, it supports happy and healthy families. Cooking together builds strong family bonds, and research shows that Blue Apron families cook nearly 3 times more often. And again, particularly during the holidays, if you are the chef who is responsible for the holiday cooking, you're going to love having Blue Apron give you a hand with that and having your family members give you a hand in the kitchen. New recipes are created every week by Blue Apron's culinary team and are not repeated within that year. They have such dishes as Jamaican-style vegetable turnovers with marinated orange salad, spicy shrimp and Korean rice cakes with cabbage and furikake, Swedish meatballs and mushroom gravy with mashed potatoes and lingonberry jam, Parmesan-crusted chicken with roasted broccoli, and mashed sweet potatoes. I'm going to have to go have lunch now. Those all sound so good. Check out this week's menu and get your first 3 meals free with free shipping by going to blueapron.com/twit. That's blueapron.com/twit. Thank you so much, Blue Apron, for helping us out in the kitchen and for your support of This Week in Law. Blue Apron, a better way to cook. We should have asked Mark on the show years ago, and I guarantee you we will ask him on again now that we've actually lured him into our lair. But the thing that prompted me to want to get in touch currently is Mark is the author of perhaps the greatest legal brief ever written. And it's just been filed. It's in advance of a hearing that will take place next week in the Central District of California, in a case involving, I think it's Paramount Studios and CBS. Is that right, Mark?
As far as I know, it's only Paramount, but I'm not really paying attention to the main case. I'm only paying attention to my one minor issue in it. But
right.
Yes, but Paramount is definitely the plaintiff in this case, up against a movie company that is trying to make a piece of fan fiction. About, I guess, a prequel to the entire Star Trek universe of films.
Yes, and it is called Axanar. We have a clip here called Prelude to Axanar. This is it wants to be a crowd-funded fan film based in the Star Trek universe, starring Richard Hatch, among others, who folks will remember if they were Battlestar Galactica fans in the 70s, and various other things that Richard Hatch did. And it just looks wonderful. We'll let you watch a bit of it here.
The fact that the humans could lead the formation of the Federation just a few years after their war with the Romulan Empire is nothing short of extraordinary.
But it represents something very different to the Klingon Empire. Growing tired of diplomacy, their High Chancellor proclaims, if words were water, the humans would drown us all.
The bad blood between the humans and the Klingons meant that the job of preventing war and leading the peace delegations fell to Vulcan. Regrettably, we failed.
All right, so I'll let you all watch the rest of this wonderful Prelude to Axanar on your own time after the show. I'm dying to see it. I hope they get it made. But there is a fly in that ointment, and that is the fact that the rights holders, Paramount here, are claiming that the entire endeavor violates various copyrights that they own. They've procedurally, they're at the very beginning of their lawsuit. A complaint was filed. A motion to dismiss that complaint had some success in saying that it was too general. So a first amended complaint has been filed where some of the specific copyright violations were delineated in more detail. Things like the pointy ears of the Vulcan are claimed to be under copyright. Things like gold shirts and the insignia on the shirts themselves are claimed to be in copyright. Another thing that is claimed to be under Paramount's copyright is the films. Again, the film hasn't been made yet. They have a script. They're trying to get funding, and they have this wonderful trailer that they've done. So you can intuit some things about what will be in the film. And one of the things that Paramount has intuited is that they intend to use snippets of the Klingon language in the film. And Here is where Mark and his client come in. Mark, tell us who your client is.
Well, they are a group of people who are into creating languages, which I did not even know was a thing until they approached me, which I found just fascinating. That there is an entire society of people who are into this art. And I would say that, Klingon is probably, at least arguably, the granddaddy of all these creative languages. I think there's a good argument that Esperanto would be more so, but Esperanto being so old and nobody really trying to claim ownership over that. In fact, the inventor of Esperanto immediately dedicated it to the public just in case there was ever any argument. But yeah, my client is the Language Creation Society, and you can find their website at conlang.org. Just fascinating. I mean, I would say go to the website or don't go to the website if you have something to do, because I found myself just sucked into a hole hours and hours long because there's just so much fascinating stuff on it. I mean, this is I sent them actually, these guys, I sent them an email this morning, both thanking them and in part cursing them for how much time they had taken from me.
We also have...
So Klingon is just one of the languages that they are concerned with, is what you're telling us.
Yes. I mean, there are people here, people in this organization who have created languages that have one speaker. So this is, Klingon is sort of the success story of a modern conlang.
Right. You cite the Big Bang Theory at one point in your brief because there's an episode where Klingon is used, and you're demonstrating very well throughout your brief that Klingon has taken on a life of its own beyond Star Trek. It's related to Star Trek, but beyond the episodes in which it is spoken.
Yeah, I mean, look, it may have started that way, but there are friends who only communicate with each other in Klingon. That's their only common language. And I don't care where it started. The neat thing about this is there is no analogy at all. There's never been an analogous case. I can see Paramount's thought here that we commissioned its creation, so we own it. But I think it's just a little bit too much mission creep in copyright law, which I think has probably gone a little too far as it is. I do an awful lot of copyright enforcement, but I'd say that a lot of those cases I'm doing my job, not doing the Lord's work. But I'd say if I could rewrite copyright law, it would be a hell of a lot shorter and a hell of a lot thinner. And I think that this would be the first time that somebody really, I mean, I know the Tolkien estate tried to claim copyright over its Elvish languages, but this is really the first time this has ever come to a head. And I'd have a real problem with that if it was successful.
So tell folks, and you very eloquently do it in the brief, and I encourage everyone to read the brief because it is just a joy to read from start to finish. It includes many phrases in Klingon that help make the point quite graphically that the language is a viable, creative, expressive form that's out there. Can I just comment too? I haven't seen any of the coverage on your brief. Marvel at the fonts that you use, both for the English text and where did you ever find a font for Klingon? I guess it just makes your point.
Yeah, well, it actually someone in my staff installed it, and that was like right up until the moment we filed it. I was just raging around the office saying, "Can we get the damn Klingon font? We need that." I don't think we necessarily legally needed it, but it really helps prove the point. I needed to, I felt like if the judge is going to consider this, which is, not a fait accompli, but if the judge considers this, and even if the judge doesn't, I wanted to make sure that the conversation was clearly focused on the fact that this is not a gimmick. This is not just somebody coming in with some bizarre notion. Although and funny enough, to put the creativity into using the Klingon language, I think it would have seemed more like a stunt without it. with it, you really do show that this is not just a matter of of making the argument for argument's sake. If you control a language, no matter where that language originated, but you control a language, you control an entire mode of thought. I mean, I don't know how many of you are multilingual, but I am, and there are thoughts that I have. There are times when I have to take a thought that originally percolates out of the source code in my brain in Italian, and I have to, in my head, translate it into English, even though Italian is not my first language. There are just some thoughts that work better that way. There are some things that just don't translate. There's all those websites you can find where there are like 50 phrases that are just beautiful in some languages that have absolutely no meaning in English. Like I'm sure there's a German phrase for, the joy of seeing someone else suffering while they are wearing lederhosen and eating French fries. There's just there's like a French term for feeling homesick for a place you've never been before. I don't know what it is, but and in Klingon, the fun thing is it does shape the way you have to think about things. Because I was looking for, how the heck do you say intellectual property law in Klingon when there is no word for intellectual? This would be a very weak trait to have as a Klingon. So you need to look at it. And what I came up with, I was immediately, like within hours of the brief circulating, immediately scolded and berated for my awful Klingon and saying that this is not how you would say it. And the person was, I would not say unhinged about it. They were I think they were absolutely right. And I looked at it and somebody else read it and said, what a jerk. And I said, no, not what a jerk. That guy's awesome. This is the most fantastic thing that could possibly have happened because it's showing if you can argue about how to actually grammatically express something in a language, then I think that proves right there that it is not something subject to possession or ownership or control.
Right. You have one really good example in the brief, too. By the way, the term that Mark came up with for intellectual property law was mind property law. What was the alternative that was suggested by your irritated reader?
If you can wait just a moment, I will look that up.
All right.
It was just, it was great. You know what? I'll find it at some point, or maybe somebody in the chat room can find it.
Right.
Which I'm not in right now. So.
Okay. Yes, we'll see.
I'm way too ADD to do like this and that at the same time. You'll barely be able to restrain me as it is. I don't need to have like 3 conversations going on at once.
Okay, whatever we can manage. But the other really good example of how things sound very different when expressed in Klingon and grammatically in Klingon than they would in English is the translation of the Sesame Street song that you put in. Can you give us that one?
Oh, I loved that. Yeah, because it actually says like, it's the day of the sun has to flee because of fear. I mean, it's just. So
the original lyric is "sunny day chasing the clouds away,"
right?
And the translation in your brief is "day of the daytime star. The clouds are filled with dread and forced to flee."
Another member of my team came up with that. So Jay Woolman put that in there. So I don't know where he found it, but shout out to Jay Woolman for finding that. It was brilliant.
Right.
We also have This Week in Law translated into Klingon, courtesy of Pedelanti in the chat. I'm going to butcher this. I'm sorry, Klingonese people, but it looks like Kastavis shoot. Oh. This Week in Law.
Love it. Yes, I'm not going to try and butcher it. And we've had the conversation on the show before, and I wonder if you had to go through this, Mark, when you were drafting the brief, and if you made a decision one way or the other, whether it is Klingon or Klingonese.
I say Klingon. I don't think Klingonese sounds. First of all, it has a syllable that you don't need. So why be so wasteful? I think that'd be a very non-Klingon trait to have. You know,
yes.
One fun thing I learned is Klingon doesn't have any word for hello or goodbye. Instead of hello, you just say, "What do you want?" And
love it.
And if they don't want anything, then why are you standing there? And then instead of goodbye, at the end of a conversation, when you have nothing left to say, you just leave or hang up. Which is good, because that's how most of my conversations end anyway. That just because I forget what I'm doing and I dodder off. But
it's very efficient. I think we can go with Klingon too, because where I get Klingonese from is from the Trouble with Tribbles episode, which featured Klingons that didn't yet have ridges on their heads, right? So maybe that's an antiquated usage when they call it Klingonese. Yes.
You know, that's so funny. Until I did this brief, I didn't realize that was a thing either, that I just always remembered Klingons as always having the ridges on their head, even though I am, old enough to remember the episodes when it wasn't there. They just looked like dirty people back in the day.
Yes, definitely. They needed a mustache to twirl, and I think in the Trouble with Tribbles, they might have had one. At least the truly baddie did.
Well, there's something, but there's so of course people have to come up with these backstories to why it all has to fit, and the story was that there's, at least that I read, is that there is some kind of a virus that transmitted itself from Klingon to Klingon. So now all Klingons have this ridge in their head because it was a virus, but it's a sign of pride because there's a Klingon insult that says your grandmother or your mother has a smooth forehead. Mm-hmm. And that's an insult to a Klingon.
It's a bad thing. Yes.
Yes.
Gotcha.
So under Chaplinsky, you could possibly be punished for telling a Klingon that their mother has a smooth forehead, even though that would be a relatively recent development. Like your grandmother could have a smooth forehead, according to the story.
Mm-hmm. So you make the point. Everybody's grandmother should, right? Because it all.
One would think, but you see, now here we are in a complete nerd world.
We've gone down the nerd rat hole. Let's go down the legal rat hole a little bit. The crux of the brief, which, by the way, we should explain to people. We've talked about amicus briefs on the show a lot. An amicus brief is a friend of the court brief, not filed by a party to the case. So Mark's client is not a party here. They're just interested in the outcome and strongly believe that the Klingon language is not copyrightable.
We're just Kling-splaining.
Yes, exactly. So it's taken on this life of its own that there certainly you could do things in Klingon that are copyrightable. And you point out in your brief, Mark, that if Paramount wants to assert a copyright in various Klingon phrases used in various Star Trek episodes or movies, more power to them. But when others are using the language, that's a different story, correct?
Right. I mean, I think a phrase itself might be a little too short, but yes, if Paramount wants to put out I've seen some things, man, in the past couple of weeks. Like Sai, who is in the chat room right now, I want to reach out and choke him because he keeps sending me videos of music in Klingon, and of course I can't resist but click the damn thing. And just when you see people like in Platoon where they talk about I seen things, man, you get the 1,000-yard stare. You will never bounce back from seeing Gangnam Style in Klingon, perhaps even the original Klingon. But
well, let's see if we can get people to bounce back from seeing Kiss Me in Klingon, because we have that one queued up. Victor, can you indulge me in this? Or no, I'm sorry, it's Miss Me or Kiss Me? We'll see.
I don't think we'll be able to understand anyways.
Yeah.
Shoot red dark ding ding kamad teding moch pak vet til tuk et pak varm vi tuk chef khicho et shostish bing da khicho khide rada khofu bing da
kiss me, because the Klingon translation is bite me.
What a fantastic world we live in, though. You know, isn't it? I mean, isn't it just fantastic that there are people who are this into this, that woman got not only knows Klingon well enough to do that, dressed up like that, made a video of it. My hat's off to people who have the time for that and the creativity for that.
Well, Mark, I did read the brief. I thought it was a terrific read. I am curious as to whether there's been any response by Paramount. Do you anticipate one? And also, will you have an opportunity to argue your client's cause before the court?
Well, they did oppose our filing of the brief, saying that it was irrelevant and poorly timed. And poorly timed, point given. Irrelevant, I think not. They said that they're not actually claiming a copyright in the language, although their complaint says that they are. So, you got to make your pleadings consistent with each other and to the best of your ability. I mean, it happens to the best of us. So, but they are. Will I be able to argue this? I don't know, because I know that the hearing was scheduled for Monday, but the court took it off calendar, and they're just going to do this, as they say, in chambers. So this will be just on the papers. There will be no hearing. Anybody who is showing up at the courthouse in full Klingon battle garb, go back to your homes. There was nothing to see there. I was planning to go. I had a plane ticket to go. I was going to go and just see if the court wanted to hear from me. And I was just dreading the thought that the judge was going to ask me to speak in Klingon. And then I would be called out for the Klingon fraud that I am, because I am not fluent in Klingon. But at this point, I don't think so. But remember, this case is a long time going on. It has a lot of life left in it. I'm thinking that this will probably be revisited at summary judgment. And at that point, who knows? Maybe the judge will want to hear from us. But I think now, at this point, with the brief filed, Axanar's lawyers, the defense counsel, now has all of our arguments. And as far as I'm concerned, they can steal them and use them for their own, and thus maybe even make our involvement irrelevant. I'd love to be able to argue it, but I'm more interested in seeing the actual cause vindicated, and that is that copyright just does not need to be expanded this far that it could control a process or a language.
One of the most interesting topics to wrap your head around as we continue to develop artificial intelligence and autonomous systems in general are systems that, without any human intervention, are programmed to go in and kill stuff. So, Rebecca, can you kind of give us the lay of the land, where things stand with those kinds of technologies right now, and how the world is grappling with regulating them?
Sure. First of all, I want to thank you for not starting off with a picture of the Terminator, because that is what everybody immediately goes to when I say I work on killer robots. So things to wrap your heads around autonomous weapon systems in terms of what they are. First of all, they're not drones. Most people think that when I talk about autonomous weapon systems, I'm just talking about drones. But drones are actually semi-autonomous weapon systems insofar as there's a human being who's making decisions about selecting and engaging targets. They're just doing it remotely, with some geographic and sometimes a slight temporal distance. Meanwhile, they're also not landmines. Landmines are geographically separated from the human deployer, and they act independently, but they act in a very automatic way. Autonomous weapon systems, in contrast to both of these sort of common or at least conventional weapons, existing weapons, have the capability of independently selecting and engaging targets. And in terms of the debate right now, there's some debate as to whether or not autonomous weapon systems already exist. There's a lot of people who are arguing that they're weapons of the future, but that they're coming soon. They're going to be here in 10 to 20 years, possibly even 5 years. There's also people like me who argue that we already have autonomous weapon systems that are being deployed. They're not always being used in their fully autonomous modes, but they nonetheless have they have that fundamental capability of independently selecting and engaging targets. And so one example, just to make things concrete, the SGRA-1 is a stationary armed robot that's used to patrol, well, it's stationary, but it's used to monitor the Korean demilitarized zone. And it uses, I believe it's actually, Kinect technology, PlayStation technology, to identify human forms and train a gun on them, order them to halt and surrender. And South Korea maintains that these robotic systems are being used in conjunction with human operators. So they're being used in a semi-autonomous mode. But the manufacturer has also said that they have an autonomous mode where they wouldn't need a human operator, in which they could independently identify a human being and engage it.
Wow. So is the analogy kind of like the autopilots that fly all the commercial planes in our skies today, that technically they can do everything that a pilot would need to do, but the pilot is there for oversight and emergency purposes? Are they operating sort of along those lines?
Yeah, I would call the autonomous weapon systems that are in use today human-supervised autonomous weapon systems. And this follows the U.S. Department of Defense terminology in one of their direct policy directives on autonomous weapon systems, where they basically say that human-supervised autonomous weapon systems are in use today.
And apologies to all my pilot friends that I just called you unnecessary. That's not what I meant at all. Apologies to Rebecca too, that right before I began the show, we did not flash up a graphic of the Terminator, but I did tweet, "Come with us if you want to live." So I am definitely guilty.
I wrote and then deleted two different tweets that were both like, I for one look forward to talking about our robot overlords tomorrow. But
there we go. I like that one too. All right, Rebecca. So we have some of these systems in place in the world today in a supervised kind of capacity. Who was it you just mentioned who said that such things must be supervised?
So the Department of Defense has U.S. Department of Defense has a policy directive saying that there are that it's okay to have human supervised autonomous weapon systems. There's also a large debate about what that actually is going to entail, what's going to constitute sufficient supervision, what the sort of jargon of the moment is, what is meaningful human control. And there's a lot of variations on what control means and on what meaningful means. Some states would say that there needs to be a human in the loop, actively making the decision every time there's a decision to select and engage a target to use lethal force against another human being. Other states would argue that having a human on the loop, just sort of monitoring the system with veto power, that would constitute sufficient human control, meaningful human control. And still other states are sort of arguing that, as if a human wrote the program and a human incorporated sufficient rules into the program that's directing the autonomous weapon system, that is actually sufficient, meaningful human control.
Okay, so we don't have agreement on that front. And you mentioned it's the Department of Defense the United States Department of Defense who has said, well, we have to have some sort of human oversight. Then we can get into the weeds over what that means. How does the U.S. Defense Department's policy translate into what other countries will do?
Right, yeah.
Well, the great thing about the U.S. policy is that it's public. As far as I know, and I could say this with more assurance about 6 months ago, it is the only public policy on a state's use of autonomous weapon systems. I think Britain the UK is the next up in terms of they've published some policy related to autonomous weapon systems, and they've come out explicitly against a ban on all autonomous weapon systems. As far as I know, they're the only state that's done that so far. But really, it's the only public state policy, military policy on autonomous weapon systems. And so I think it's just going to be huge. It's definitely been hugely influential in the academic discourse in terms of informing how states are thinking about these systems. And I think it's likely to be influential for other states that maybe weren't thinking about what their policies were even going to be yet.
So the Korea example that you gave earlier, they haven't said anything about their use of these maybe autonomous robots, besides that they may or may not have a human attached to them at some point?
They've said that they are human supervised, that they don't operate in an autonomous mode, and that's pretty much the extent of it.
Huh.
I think there is this is completely separate and tangential. I think there might be a South Korean call for a code of robot ethics. So that may or may not be related. I don't think that's a military code.
Right.
Huh. This is so fascinating. I have so many questions, but I know that we're talking about this in sort of an international state warfare context, and I'm remembering at the same time the textbook case from torts, one about trap guns. I don't even know how to frame this question. This is so crazy.
Well, first, while you're framing, let's remind our non-lawyer listeners what that textbook case was. And this is the thing that everybody learns in torts in law school, and torts is one of Rebecca's specialties as well. And the torts is liability, non-criminal liability for harming people in a physical way. So when they're, and also it doesn't necessarily have to be harm to people, but again, we won't get too far down the road there. What Emory is referring to is the situation where in an effort to defend one's property, someone has set up an automated gun. Typically, if I'm remembering the facts of the trap gun case, right, I think it was in the garage.
Yeah.
And if the door is opened, the gun goes off. It's set up just to fire, the landmine example that Rebecca gave earlier, except this time it's a gun pointed out the door. And this is a case that every law student studies, and it's a classic example of how, no, you can't do that. Yes, you're going to be responsible if you injure somebody with this sort of defense mechanism at your house. So have I filled enough to give you time to frame your question, Emory?
Yeah, I think so. So, I mean, for all of our non-legal experts out there, and I mean, actually anyone can probably understand that the importance there is that in the trap gun case, there's no one that could veto that power to, kill someone. That if it happened, if, the condition is met, then the gun fires and kills someone, regardless of whether or not a human has any input in that. I know that, Rebecca, you've worked a lot, or you've written about the idea of war torts. I was sort of under the impression, I guess I don't know anything about international war law, but I was sort of under the impression that every nation basically respected that idea, that you want to have a person behind the trigger. But I guess clearly I was incorrect. At least Britain has not allowed or said that they would outright ban autonomous weapons. I guess I want to just put that over to you. Do you want to give our listeners a little bit of background about war torts and sort of how this works into that discussion?
Sure. Trying to distill that. So
yeah, sorry about
weapons. That. No, it's a great question. Two things to go down on. First is the law of armed conflict obviously allows for the killing of people. It just allows for the killing of some people and not others. So there are lawful targets. There are combatants are lawful targets. Civilians who are directly participating in hostilities, right? People who take up guns and fight the enemy forces are lawful targets. And there are lawful objects that can be targeted, just military objectives. There's also unlawful targets. So that would be civilians, wounded or surrendering soldiers are unlawful targets, and civilian objects. And civilian objects include a host of different things, from hospitals to museums to livestock, et cetera. And the whole aim, I think, of the law of armed conflict, also known as international humanitarian law, is to minimize the harm and minimize the to those unlawful targets and make sure that militaries only use force against lawful targets. And there are a host of subsidiary rules that autonomous weapon systems challenge in different ways. One of the issues raised by autonomous weapon system is who do you hold accountable when an autonomous weapon system commits a serious violation of international humanitarian law? These serious violations usually are committed by human beings, and they're called war crimes when they're committed by a human being, because a person has to act with intention or with recklessness to commit a war crime. But you can imagine a situation where an autonomous weapon system, because of its capability for independent action, takes some action that would constitute a serious violation of international humanitarian law, but nobody along the line, from the programmer to the developer to the manufacturer to the commander to the deployer, no person acted willfully, which is to say with the intention of causing that violation, or recklessly, acting notwithstanding knowledge of the likelihood of the consequences. And in that very hard case, there's no one who can be held accountable under existing international humanitarian law, international criminal law, rather. There's no individual criminal liability when there's no willful action. And so I make the argument in my war torts piece that that this is an issue that's highlighted by autonomous weapon systems, this possibility of serious violations where nobody acts willfully. And we need a new legal regime to address when this happens. And autonomous weapon systems highlight, that it happens, but it also happens in other situations. I think there's a case to be made that things like the bombing of the Doctors Without Borders hospital might constitute a war tort, if not a war crime, insofar as it was found that nobody acted, the U.S. found in their investigation that nobody acted with intention and nobody acted recklessly. They attribute it to some technological errors. And I think there's a case to be made that that's a war tort, and that there's a need for war torts to minimize these actions that are otherwise there's no accountability for them, and also to provide compensation to the victims of those actions, which is part of the point of tort law, both minimizing on the front end and providing compensation on the back end. Going back to your original tort case example, and this is where I say the law of war allows for killings. There are such things as landmines, right? There are such things as tripwire sentry guns, and that depending on how those are used, depending on how those are deployed, depending on whether they're anti-personnel or anti-tank, they can be lawful under the law of war. So it's not domestic law, which presumes that killing another person is likely unlawful. It's quite the opposite in the law of war.
Do you see any traction being picked up about the idea of war torts? Because I agree, it sounds like...
So it's very new. The piece that I wrote actually is in the final stages of publication right now. So I'm actually just initially right now trying to get the word out. I don't have the formal finalized published piece even yet. And that piece really focuses on autonomous weapon systems, how they raise this problem, how war torts might be, how there might be a good, autonomous weapon systems might serve as a good pilot case for establishing a war torts regime, that it's sort of so clear that you have these accountability issues there. I'm hoping in a future piece to construct a stronger, broader argument for war torts more generally.
So is the defendant in a war tort kind of action where it was a technological issue that brought about whatever disastrous result is at stake, is the defendant always going to be the manufacturer of the system, and does that pose problems because those manufacturers may be governments who are immune to liability, or maybe on the opposite end, some third-party non-corporate actor that is, black market throwing weapons together that are being used in war?
So that highlights the problem with trying to have individual tort liability for work crimes is that there's going to be a bunch of conflicting domestic tort law regimes, just as in the United States, we have a bunch of conflicting state tort law regimes. I'm arguing that at the international level, the states deploying the autonomous weapon systems are the entities that should be held accountable for war torts. And there's some precedent for this in prior cases before the International Court of Justice, but I think it should be recognized as its own issue. And then those states can then kind of turn around and determine through their domestic law processes what entities are the appropriate ones to hold liable, whether or not it should, the deployer or the manufacturer or everyone should be immune, and it's just a cost borne by the state when it conducts warfare.
So I guess a different way of framing my question is it just a different way of looking at a product's liability issue, just a different context?
So in some cases, it might be. The U.S. military often immunizes the manufacturers of its weapons from tort law cases. So in order to provide incentives for them to continue to manufacture weapons. So that might not fly in the U.S. legal regime, but nonetheless, at the international level, the United States as an entity could still be held accountable, let's say, for the bombing of this hospital and pay, under a legal regime, pay appropriate compensation to the victims.
Again, this is sort of a follow-up to the more in-depth show we did a while back on lethal autonomous stuff. There's a good piece at Vox.com about creating rules for how the police can use lethal autonomous stuff, either whether it's autonomous or remotely controlled. I think we're lumping in that article. But what I wanted to highlight for people that I found really fascinating is this project that is part of MIT. It is called Moral Machine. I think it's part of the Media Lab, MIT Media Lab, Scalable Cooperation, and MIT itself. The Moral Machine is a platform for gathering human perspective on moral decisions made by machine intelligence, such as self-driving cars, of course, also such as other more overtly lethal stuff. And what this does is shows you moral dilemmas. It is so depressing. I have walked myself through the 12 scenarios that it presents to you, and I think it presents different scenarios to different people, where a driverless car must choose the lesser of two evils, such as killing 2 passengers or 5 pedestrians. So you're supposed to judge the outcome you think is more acceptable, and the goal of you can also suggest scenarios if you think that they're not getting at the crux of some thorny ethical dilemma that a lethal decision-making system might have to autonomously make. You can help them design scenarios that they can then have other people answer. It's really fascinating just to help them gather this information. So I thought that perhaps our audience might be interested in providing MIT with their 2 cents about the lesser of these evils. Did either of you take a look at this, Amanda?
I just saw that there was a dog versus cats one, which is sort of surprising and interesting. But I actually had a question. When you were going through, did you take the scenario seriously and answer the way that you would like an autonomous vehicle to respond? Or were you just looking to see what the different outcomes were?
I took it seriously, and I think that's part of the problem of their information gathering. Right? There are probably people that wouldn't do that.
Indeed, I'm sure there's already people who are saying, "Is there a way for the car to just swerve and kill everybody?" And we would like to suggest that, which is troubling because if you're going to crowdsource morals for machines, and it's sort of in the same way that you are curious about reducing algorithmic bias, if you're having human inputs, there's going to be some issues that diverge. You're going to have biased algorithms from biased humans, and you're going to have immoral outcomes from folks who are either doing it for messing with the system for the lulz, as it were, or who actually just have a moral perspective that diverges from what would normally be a majority view.
Yes, and hopefully they can correct for that a bit.
Yes.
One of the variables I found really interesting in going through their scenarios is that there is this aspect you're supposed to factor into your decision making, whether the people to be killed are morally okay themselves. I mean, it factors in, you're presented with whether the driver of the car who's about to crash or the person in the intersection is a criminal, or whether the people in the intersection are crossing against the light or not. That's a variable that comes up over and over again. You know, do you take your life into your own hands if you're crossing against the light? And I think as these systems, self-driving cars being a good example, become more and more prevalent, that you're taking your life into your own hands, because that might well be one of the ways that they're programmed. They're, like an ambulance or a fire truck, that not that they're able to control the lights, but they're able to have information that's fed to them about whether the light has turned or not, and that they make some assumptions based on that, and they're not going to be able to slam on the brakes if you assume. And just coming back from New York, Amanda, my God, people cross against the light there.
Oh, yeah.
It was freaking me out. Don't do that in California. We wait for the light.
No, you don't do that in California. That is how you get a jaywalking ticket. But here, it's a really different situation, and I'm curious about whether, sort of, not necessarily from a moral perspective, but whether social context should affect how autonomous vehicles behave. Because if you tell an autonomous vehicle that anyone crossing against the light is fair game, New York City is in real trouble if they start rolling out autonomous vehicles. Myself included. It's big trouble.
Right. I can just see the disaster movie taking shape as we speak. Mike, any thoughts?
Yes, so I actually went through, and like you, Denise, I took the test very seriously, and it was, I was somewhat troubled by how I rationalized certain decisions as I kind of looked at it.
Mm-hmm.
I would go through, and there was, there was one scenario. I think the opening scenario was, at least the one that I was presented with. You're in the autonomously driven car, you've got a child and a mother. And then in the crosswalk, you've got three old ladies. And so you choose between, which scenario, who do you save? And I saved the baby and the mother. And then which seemed to me to be maybe a little bit easier dilemma. I hated being given the choice, and put to the test here, but I did save the baby and the mother in that scenario. The other scenario that was maybe a little bit more difficult that I found myself rationalizing through was there was one car with three athletes, and then in the crosswalk was three men. And I'm kind of thinking to myself, okay, well, geez, who do I do? These three men, maybe they have families, maybe these three athletes are troublemakers. And so I'm kind of literally going through this calculus, albeit briefly in my head, to see which way I should decide. And then there was another one where I thought, well, it was similar to the first scenario where it was the baby and the mother and the three old ladies. And I thought, well, last time I saved the mother and the baby, so this time I'm actually not going to save the mother and the baby. So it was like, it was interesting how I kind of rationalized my way
trying to come
to
a kind of equilibrium in your decision making.
Yeah, exactly. Trying to spread the pain, I guess, in some ways. The easier dilemma for me was there were some scenarios where it was a dog and a cat. Save the animals or save the people. I mean, that from my perspective was a pretty easy situation. It was curious, though, that some of the people that you would be that you would be given the choice to save would be, criminals versus doctors. And I don't know how an autonomous vehicle necessarily can differentiate between the two. But I found myself, when I was faced with that dilemma, of course, saving the doctors versus saving the criminals. So I don't know. It was very fascinating. I encourage people to take a look at it. If nothing else, I think it's an interesting exercise to see how you, if you were an autonomous vehicle, how you'd go about making that determination.
I wonder if actuaries would provide an interesting point of comparison for just sort of normal interactions with the moral machine, because actuaries are trained to sort of make these kinds of judgment calls about You know what I mean? And when they're appraising insurance policies or what have you, they're using math and statistics to figure out what are the likelihood of potential outcomes. And I wonder what the results of that moral machine input would be as compared to folks who are making more sort of what you were saying earlier, Mike, sort of gut or, trying to reach an equilibrium rather than maybe something that's really solely rooted in a mathematical model. I'd be curious to hear more about that.
You hit on something, Mike, that did completely creep me out while I was taking that, and that is that these researchers at MIT seem to be assuming that the machine will know whether you're a doctor or a criminal or your age.
What happens to the doctor criminal? What happens to that person? I don't know that the autonomous car is prepared for that.
No, that's right. There's some bad docs out there. Lots of litigation going on around the country about ballot selfies, legalizing them, not legalizing them. The state of New Hampshire just got a ruling where folks can go into the polling place and take a picture of their ballot. This is not technically a selfie in that the ballot is incapable of taking a picture of itself, but there are many places in the country where that is not okay. There are others where it is. We'll point you to a resource later in the show where you can figure out exactly where you stand as far as being able to take a ballot selfie and post it or not. But many people like to do this. It sort of goes along with those, hey, I voted stickers for people to be able to demonstrate that, yes, they were there and they placed their vote. Here in California, we have very good vote by mail laws, and I haven't seen the inside of a polling place in many, many years. In fact, I sort of took my son into one, sort of like a museum visit that was at his school, because schools and libraries and things are frequently polling places. And since I've never been to one, he'd never been to one. And we went in, we toured it, and they gave him a sticker, and it was very, very nice. But for me, the physical polling place is no longer relevant in my life. That's not true of many, many other people in the country. And there's no reason why you couldn't take a picture of your vote by mail ballot as well, except if it's illegal in your state, which it is in California. So anybody have anything to add to the whole ballot selfie issue? There seems to be a sort of freedom of expression, promoting voter participation aspect to these disputes, this issue that comes into play. Venkat, what do you think?
I would agree. I think it's a great decision that recognizes the expressive value in pictures and the type of stuff people post online. I think it was interesting that Snapchat participated or submitted a brief as a friend of the court. I'm not a Snapchatter, but it was interesting to see that they chimed in and the court actually cited from their brief favorably. So overall, it's a great decision. I like it. And I think it calls into question a lot of these other restrictions in other states that try to restrict posting selfies in the voting context.
Mm-hmm.
Right. I guess the counter argument is they're trying to prevent voter fraud. Somehow they think that photography in the polling place is not a good thing. It's a security issue. I'm not quite sure. I haven't read the briefing in the case.
Yeah, that sounds ridiculous.
Yeah.
What an insane argument that having visual photographic evidence of my vote somehow encourages voter fraud. What?
Yeah. Well, yeah.
I don't know. I think this is the argument that ballot selfies in any way sort of erode the sanctity of voting. I think is like a very bad argument to be making, considering that our voting percentages are approaching 50% in the best of times, and we're somewhere closer to 30% during the last midterm election. So anything we can do to make voting a more entertaining, a more civic-minded, a more community activity, if that involves posting it to social media, I think is probably a good thing.
Right.
Yeah, I agree. I mean, I'm not that familiar with the dispute either, but I assume that they're worried about, or these states that have these laws are worried about selfies with the ballot, and then people get a look at what the ballot looks like, and they can gin up fake ballots and then stuff the ballot box somehow. I mean, I assume that's what it's got to be at.
All right. Well, the other thing is
this seems so painfully unconstitutional. I mean, it's a content-based restriction. You're restricting the content of a photograph that somebody can take, and it's clearly content-based. It's got to be unconstitutional. I'm glad to see that the First Circuit is making ballot selfies great again.
Absolutely.
And to the point of voter fraud, there is so much possibility of voter fraud in democracies going back forever. If we're like, this is not the kind of thing that could prevent ballot stuffing or could prevent wide-scale voter fraud at all. The real threat to our voting system is the terribly insecure infrastructure that we have. We had an article about this a couple of weeks ago, but we have effectively 9,000 equally insecure county voting systems. Where it only takes one or two of those to be compromised to turn an election. I'm not at all worried about people posting their voting results on Snapchat. I think that's insane and just distracts from the real point.
Right. And I think the two reasons given by the legislature were voter coercion and vote buying. I think were the two ways they tried to justify the law. And to me, it seemed pretty antiquated, and the court said, these are just hypothetical concerns that may have been around way back when, but there was just scant evidence of it. And the one interesting side note to this ruling is there's a footnote that actually talks about a selfie being defined, and this was from Snapchat's brief, being defined not strictly as a photo where the photographer is also a subject, but rather all smartphone pictures shared online, including those here. I thought that was kind of funny that a ruling from a federal appeals court would delve into the definition of selfie. So there you have it.
A little broad. Talk about bludgeoning an ant. Isn't it? Are we getting perhaps to a point with copyright law, Joe, where the blurred lines case being an example, the Led Zeppelin case being another, where we're starting to see the law being used too aggressively?
I think so, because there isn't a theory of the psychology of creativity created by a theorist called Arthur Koestler in the 1960s, and it's the theory of bisociation. Put simply, everything is a mashup of everything else. And it goes back to the ancient Greeks, Aristotle, nothing can come from nothing. The idea is that all music is in some way derivative of music that's gone before, and pop music is an evolved art form. So I think the blurred lines case kind of frightened a lot of musicians, because anyone with any kind of musical training or anyone who's ever written a song or played a cover version could hear very obviously that these were different songs. And yet they shared certain characteristics. What the Gaze Estates family estate musicologists called a constellation of coincidences of non-protectable elements. So specifically in the case of Blurred Lines, they were a cowbell riff, a rhythmic cowbell playing all the way through both tracks, playing the bass line on an electric piano, having a falsetto male vocal, having party noises in the background, and curiously, not having a guitar was claimed to be a creative decision by Marvin Gaye that was later copied, allegedly, because it's not genre typical. So the absence of something was argued to be a copyrightable thing in some strange world. So I do think that particular case worried a lot of people, which is in the music industry, because it was so obviously not a copy, it was influenced. And because yourself, whenever you read a Rolling Stone interview with your favorite artist, they always talk about their influences. And that's kind of part of the evolution of music and how we move the art form forward. So the idea that you couldn't even do something that was stylistically based on an artist you admired, very much as Robin Thicke testified in the case, it's an alarming one for a lot of musicians.
Well, I think it's alarming if we get back to the policy aspects of copyright law for a moment. I think it's alarming for people who have watched the development of the law over the years. Derek, I'm wondering, getting back to your notion of constitutional copyright, how you think the founders would grapple with an issue like this.
Well, it's not just the founders, it's the doctrine that they sought to embody in the Constitution and the early case law and what the British thought of what copyright was designed to be. And up through the 19th century, copyright infringement required the wholesale replication of an existing work. And in fact, in the early United States, it didn't apply to the vast majority of books because they were from Britain. And those books didn't even qualify for copyright. And so we've entered a world now where any kind of externality of that copyrighted work, somebody thinks that they should get a royalty check for, and that's one argument, but that's just not even close to the same thing that the founders or the British were talking about when they wrote the Copyright Clause. And the idea that every externality needs to be recaptured is an illogical one. It's just impossible. Somebody is performing his violin outside of my restaurant, and he demands to get a payment for that. Well, that may benefit my restaurant, but he's choosing to perform on his own volition. Comedians steal from one another. Fashion designers steal designs from one another. Chefs create incredible new recipes, and other chefs borrow from that. So this idea that all externalities are to be recaptured is one that is only really argued in the copyright industry. So it's inherently a balancing act that we have to decide upon. And when we know from artists themselves that this is how the creative process works, you could see a world of infinite propertization, and it really looks crazy, right? The first person who has the first rock album, no other artist is allowed to have a rock album because they're inspired by that original rock album. That's not what we want. That's not what the artists themselves want. And in fact, the data even shows that when you're sampled by other artists, it's minimal data, but we have one study on this, that it likely increases your sales. And it's usually the best thing to ever happen to you is when you're sampled. So it's really what's going on here is it's kind of borrowing from European rhetoric about moral rights, that you have some sort of a moral interest in that work perpetually. But that's just not what the system at the American, the Constitution embodies.
And this is what I was getting at when I mentioned earlier. I don't think that the Recording Academy and the signatories to the letter to the president-elect on behalf of songwriters, performers, producers, and engineers, I don't think that they were, they seem to be more concerned with royalties than with the creative process, because the point they call out is music lovers have more ways to listen to music than ever before, but the laws governing the sale and distribution of music have failed to keep pace with technology, keeping music creators from receiving fair market value for their work. What they don't mention at all is the laws not keeping pace with or being applied in ways that impinge the creative process itself. And I think that's what we're kind of getting at here with these music copying cases.
It's kind of curious. I mean, those letters come out every 6 months or so. They're circulated by the MPAA, and they have, the RAA, and they have, big artist names on them. But they're always about not getting enough royalty money. But it's always written by the people who are getting the most royalty money, and they're never really talking about the creative process or what it's like to sample from one artist to another. And I'll just give you an example, which is that if you're trying to create a song, which is like Puff Daddy, "I'll Be Missing You" in the 1990s, he wanted to sample from Sting. And it's widely believed that Sting said, if you want to sample and reuse that work for "I'll Be Missing You," I'm going to require 100% of your revenue. And you can do that, right? You can be an artist and you could say it's 100% of revenue, or you can say it's 50% of revenue and you need 2 samples, so it's 100% of your revenue, or it could be 3 artists and it's 150% of revenue. That's the system that we have now. And as a result, we have a lot of artists like Public Enemy who has publicly said they stopped making music because they could not make the type of music that they were making. But you never see that reflected in these letters. And I think both things are important. We want artists to be well compensated, but we want the artistic process to be able to continue.
I think we can all agree on that. What I think is the mystery here is how we get to a place where artists are compensated in the way they claim is necessary to pay attention to in the letters that you're referring to, Derek, and that the creative process is protected and recognizes what's happening not just compositionally, but technologically in the music industry. There's so much changing in the music industry so rapidly. There's some great posts on Joe's website that we're going to talk about in a little while here, highlighting some of the ways that technology is altering the music industry. But before we get to those specific examples, I guess I just want to ask all of you, how do we fix this? What do you think, Mike? Easy
that's
question
a huge,
for the day. Yeah.
Yeah, that's a huge question. It's such a multifaceted issue. And as I mentioned at the outset of the show, I mean, I think that music copyright is probably the most complex and most complicated area of the law when it comes to copyright. I think there's certainly a very sound argument to be made that copyright has expanded so incredibly far outside of its original intent. As Derek was mentioning, the first Copyright Act enacted by Congress, I'm pretty certain that it didn't even protect musical works. I think that came about.
That's correct,
music became protected, I want to say, in like the 1830s when there was an amendment to the copyright statute. And of course, sound recordings didn't even exist back in the 1790s or even in the 1800s when music was finally protected. So, we've gotten to the point where millions of dollars are being expended on cases involving the sampling of, less than a second worth of music. The Madonna En Vogue case that was recently decided by the Ninth Circuit is a really good example of that. I think, it makes sense to re-examine this area and have we really gone too far here? I argued years ago, and I know we're probably nowhere close to this happening, but to me, it would make sense to have some sort of compulsory license system that's going to allow people to use musical snippets from prior works for some sort of modest royalty. I'm not sure that that's ultimately a workable solution, but it seems to me that this is endemic to the art form. As Joe had mentioned, a lot of musical inspiration comes from pre-existing works. I mean, look at, for example, works of any of the great classical composers, Bach, Beethoven, Haydn. I mean, they all copied from each other and, created these incredible works that have endured over many centuries. Our own Star Spangled Banner, for example, the music to that's not something that was made here in America by an American composer. That's actually an old English song that was borrowed. To Anchronon in Heaven is the name of that original English tune. So, I think you could look, and Joe would certainly know better than I, but you look throughout the course of history, there is a healthy amount of copying particularly with this art form. And I think that should be respected and taken into consideration in any sort of modification that's going to be made to the Copyright Act. So I'll step down from my soapbox now.
That was a great answer, by the way. Joe, do you have any suggestions as to how the situation is capable of being aided in the future, or should we just look forward to more lawsuits on more discrete parts of songs?
It's bizarre that we're trying to settle this whole thing case by case through the courts. I'd just as a musician and a creator, I'd really like to live in Mike's worlds of compulsory rights and pay a royalty, because a lot of the time musicians would be happy to pay that royalty. Of course, you'd then end up over time getting derivative works of derivative works, and there's a lot of arithmetic to be done of who owns what percentage of what. But I really do like the idea of that. I think there are two specific things the law could do, and I should just caveat what I'm about to say with the fact that I've only been in the US a year and a half. So I'm still learning quite a lot about US law and specific US case law as opposed to European law. And Mike mentioned moral rights as an example of something Europe has that the US doesn't in the same way. But specific things that I think US case law could do, US copyright law could do, and I'm going to use blurred lines as an example. A lot of musicians, as we know from the amicus brief that was filed a few months ago about blurred lines, a lot of musicians thought no notes have been copied, therefore it's not a copy. And yet, I think there's an argument that it was an intentional copy, that the blurred lines was an intentional copy. You've got to give it up. It copied a bunch of elements that hadn't been combined in that way. So my first utopian law would be to expand the definition of a musical work to be everything that we hear, so you don't just have to have mechanical reproduction of a sound recording to infringe a copyright. Everything could be protected. So a pant, the sound dogue, as the George Clinton example showed us. But at the same time, I think we should try and raise the threshold of substantiality. That is, you should be able to get away with copying more, with or without paying a royalty. That's maybe something for the industry to contribute to. So two things, really. Expand the definition of a musical work beyond the notes, because that represents what creators are doing now. People compose straight to computer in many cases. And secondly, to raise the threshold of substantiality, certainly beyond 1 second of sampling, to allow people to use more borrowing in their work, and if necessary compensate the original owners. But certainly the idea that the original copyright holder can just demand that something is taken down. I think it was Derek mentioned the Every Breath You Take example, and I'll Be Missing You. I will just take a moment to talk about that, because although it wasn't a case, it was just a business deal. As Derek said, it was quite widely reported. I've got a guitar here, which I'm just going to use to demonstrate my point.
Please.
So the riff in question, for those who know the 1997 track, or even for those who know the Police track, the original 80s track, Every Breath You Take, is this guitar riff, 8-bar guitar riff. And so on. Ran out of riff at the end there. So it's eight bars of music, and it was sampled in its as the entire guitar accompaniment. That's from the original Police record, Every Breath You Take. And it was used in the Puff Daddy hit, I'll Be Missing You, as accompaniment for the chorus, and indeed throughout the song. Those 8 bars just looped throughout the song. And yet lyrics were changed and new material was added. But as Derek was saying, they approached Sting as the creator of the musical work. Presumably they licensed the sample as well, but approached Sting as the creator of the musical work, saying that they wanted to use it, and the response was yes, but we want 100% of those royalties. So in terms of moral rights, Sting is now co-credited as a composer of that, but more significantly receives 100% of the royalties, even though the later work added a lot of new creative material. And the interesting thing about the Every Breath You Take riff is that the chords, the underlying harmony, so we've got that very distinctive Andy Summers guitar riff with that sort of muting thing going on. The actual chords, A, F sharp minor, D, E, and back to A, are the chords of many songs. For example, Benny King's Stand By Me. The chords are actually the same. It's a fun party trick. You can try singing Stand By Me along to Every Breath You Take at some point. And of course, so that is an example, at least in harmonic terms, in chord terms, of a commonplace work that was not original at the time of Every Breath You Take. So I keep coming back to this musical question. What exactly has been copied? And until musicians and hopefully copyright law is willing to has some way to define what it is that is protected in a musical work, we're going to end up with everyone going after these big hits in the way that we're seeing in recent case law.
We discussed this lawsuit on the show, 2 or 3 weeks ago. The lawsuit about the places you'll boldly go, a Kickstarter project that looks like it's not going to get off the ground. They were hoping to crowdfund a book that was a mashup of Dr. Seuss and Star Trek, of course. So unfortunately, though, the copyright police look like that's not going to make it happen. We discussed that in some length on the show, but we did not discuss it in verse. And Mike did on his blog, thetmca.com. So, Mike, I just need you, I think, to read us some of your favorite passages from your post.
Wow, where shall I start?
Or maybe the whole thing. It's not very long.
I could give it a go here.
Your best dramatic.
Oh, okay.
Reading, please.
You've got it on the screen.
Yes.
Okay. Let me see what I can do here. All right. So it goes something like this. It's called Dr. Seuss, Susan Souville this holiday season. You know, Green Eggs and Ham and the Cat in the Hat, Horton the Lorax, and others like that. But a new book is coming, although now a bit slow. It's called Oh, the Places You'll Boldly Go. Sure, it sounds like the book already penned by Doc Seuss, but it's not. Oh, it's not. An infringer's on the loose. Or so claims the estate of the author of Grinch. Bring on the lawyers. This case is a cinch. So the lawyers lined up and formed quite a roster, all hands on deck to take down this imposter. They filed their suit for the Green Eggs writer and sought an injunction to make things a bit brighter. Who is this villain, this dastardly soul? Who dares to infringe, Oh, the Places You'll Go? The main culprit's a company called Comic Mix, and its VP and others are in quite a fix. It is claimed they have copied a work of great fame and created confusion in the market for same. They may ask, what's the problem? Say, what the heck? It's simply a mashup with a touch of Star Trek. We know about fair use and its factors of 4. We're sure to prevail at the courthouse door. But fair use is tricky, as the defendants may see. It's not quite as simple as A, B, and C. Who will prevail? Say, who will win? The defendant's chances appear quite dim. An injunction is likely, perhaps damages too, and fees for the lawyers. After all, they had to sue. For what appears to be a very good reason, Dr. Seuss, Susan Souville this holiday season. We will keep you all posted. It should be quite a sight. Happy holidays to all, and to all a good night.
Yay!
Yay! That is so good.
I know, I love it. I'm just hoping that the case makes it to an appellate decision somewhere and some of your verse can be quoted.
Now that would be fun.
Yes.
Absolutely. That would be great.
So, I mean, nothing more really to share on that front. The lawsuit is ongoing, and as Mike expounded in verse, we will keep you posted as to what happens with it. We'll keep an eye on it for you. We'll have to just pull Mike out of the 12-step program that we're going to put him into fairly soon here, because I don't think he's actually able to stop writing in Seussian verse. But
that should be all your briefs from now on. Yes. I'll have to rhyme.
Well, you know, somebody's got to try to give Mark Randazza a run for his money, you know, writing a brief in Klingon. So, you know, I'm just doing my part.
I'm so glad you've joined us for our Best of 2016 episode of This Week in Law. Thank you so much for being there with us throughout the year and on into next year. We couldn't do this show without you. We're so glad that you enjoy This Week in Law, and that you support our sponsors, and that you support the TWiT network in general. We're thrilled to be here, and we look forward to discussing much more technology, policy, and law in the new year. Have a great one. Take care.